Hello, I'm Joanne Sefton, the in-house barrister here at Mitchell Law. This is the Mitchell Law Tea Break, an occasional series of short videos for HR professionals discussing employment law topics. Today we're looking at sexual harassment at work, particularly in the wake of the Harvey Weinstein scandal and the #MeToo movement. I'm joined by my colleague Catherine Mitchell, Director of Mitchell Law.
Hello. Before we get into our legal look at sexual harassment, I'd like to start by thanking everyone who's taken the time for watching our previous videos.
Over 500 on different platforms, not that we're counting.
Well, no, I don't think we're able to claim we're YouTube sensations yet. I don't think Zoella's got very much to worry about, but we've had some really lovely feedback from contacts and clients enjoying what we've done. So it was a bit of an experiment for us, and it's been great to have it so well received.
Absolutely. Should we get back to the subject then?
If we must.
Okay, so my starter for 10 is this. I think employment law actually does okay on sexual harassment at work. Of course it's a problem, but the fix isn't to change the law. We already have laws to deal with it. The fix is to change practices and attitudes so it isn't acceptable, and to actually use the laws that we already have rather than try and change them.
I'm not so sure that everyone out there who's posted a nightmare story with a #MeToo hashtag would agree.
Yeah, I'm sure they wouldn't, and I also think it's worth making the point that we're not talking about how well the criminal justice system handles allegations of sexual offences. Even though some of the conduct we're talking about might be criminal, it seems clear there's some pretty major issues over there, but we couldn't talk about the criminal system with authority.
So it's employment claims against sleazy bosses who keep staring at their colleagues' chests we're talking about.
Yeah, well, part of the problem with discussing this whole issue is what sort of behaviour are we talking about? When I say sexual harassment, what I have in mind might be very different to what you're thinking of. Having said that, perhaps the old chest gazer is not too bad a place to start.
And what was it they called him in Bridget Jones?
Mr. Tits Pervert.
That's it.
You know, if we did turn this into a quiz on Bridget Jones, I'd be wiping the floor with you. Not kidding.
Well, I think that's true, as in many other things. Anyway, back to employment law. It's worth reflecting that we've come a long way in a few decades in terms of how sexual harassment in the workplace is dealt with. That well-known case in 1994 called in situ cleaning and heads. That was the young man who was the son of the directors of the business accosting an older female supervisor with the charming greeting, "Hiya, big tits."
Nice, lovely chap.
Yeah. The employer argued that the conduct wasn't sexual and couldn't be unwanted unless there'd been a first instance where the employee had made it clear that she didn't want to be treated that way.
Nice.
The tribunal and then the appeal tribunal chucked out those arguments, which is why the case became a well-known authority. But the fact that they were considered worth running in the first place is an indication of how far the law has come.
Yeah, it was seen as a respectable argument until that case. And of course, since the 1990s, we've had changes to the legislation itself, which means that harassment and sexual harassment in particular are specifically prohibited. You don't have to try and squeeze it into the discrimination definition.
That's right, and the law's also clear that in assessing whether something amounts to harassment, you do have to look at it from the perspective of the victim. So if it makes me humiliated or uncomfortable, then that's enough, even if it wouldn't make you uncomfortable.
So we're left with the question, if the legal protection is relatively strong, why do we still have #MeToo and seemingly an ongoing culture of sexual harassment?
Good question. I think the first big issue is that you have to look at is proof. And when you dig a bit deeper into the facts in the in situ cleaning case, she actually alleged that he'd made unwanted sexual remarks to her on 3 previous occasions. And the tribunal found there was no corroboration for those and didn't uphold them. And in respect to the final remark, she'd kicked up a fuss at the time and it wasn't denied that it had been made. And so I do wonder if their decision would have been the same in relation to those first remarks if the case was heard today. And if we'd admitted one crass remark and she'd been found to be an honest witness, I think it might well have gone the other way.
I agree. In my more recent experience, tribunals don't sit on the fence when it's one person's word against another. They look at how all the evidence came across in the hearing, they look at the surrounding circumstances, the documents, and they will side with one party. Of course, they are human, so there might be errors in doing that, but to my mind, that's still a fairer system than always requiring corroboration when chances are with sexual harassment, it's just not going to be there. And of course, we're not talking about someone getting a criminal conviction. In those cases, the accused will always have the benefit of the beyond reasonable doubt standard of proof.
So we could get quite philosophical about how to achieve perfect justice in an imperfect world here.
Or we could go back to the Bridget Jones quiz.
No. Let's move from the philosophical to the practical. I think it's worth stepping back from the decision-making process of tribunals and applying that to employers. So say you receive a grievance about sexual harassment and it's a he said, she said situation, then many employers would feel unable to uphold the grievance.
Yeah, I think that's right, and I think maybe they could be a bit more bullish about looking at the surrounding circumstances. If she doesn't have any reason to make it up, if it seems genuinely credible, perhaps if there's been concerns in the past, decide to accept that allegation. Is there a problem with that?
Well, I don't think there's a legal problem, and if they've investigated and reached a conclusion that it's reasonable on the basis of the findings, that's good enough. They don't have to prove that he did it. They don't have to be 100% convinced themselves. But it's not just about the legal problem, is it?
In what sense?
Well, if he's your top performing salesman, for example, or he's the head teacher of a school, and it'd be a nightmare to recruit another one.
Or if he's Harvey Weinstein and owns his own production company.
Well, exactly. There might not be a legal barrier to disciplining these people, but it might not be that good for business.
I guess there's been a view that if you've got your hands in the till, say, you're no longer going to be welcome, whatever other great things you might be doing. But there has been a view in the past that sexual harassment and doing a great job for the company aren't incompatible in the way that something like dishonesty certainly is.
Yeah, well, except for the female talent that leaves and the dishonesty that arises from the cover-up.
And the car crash lawsuit that eventually comes about when the non-disclosure agreement stops ticking.
Yeah, and unfortunately not every business takes such a far-sighted perspective on that, and perhaps we're moving in that direction, perhaps more of them will.
One thing I'm interested in, do you have any sympathy for the political correctness gone mad argument? All those middle-aged newspaper columnists out there saying that they won't be able to pay a lady a compliment anymore.
I'll have a think about that. No.
Care to expand?
Well, I think one of the main reasons that the law is ineffective in dealing with sexual harassment is the fact that it takes effort, guts, and often a lot of money to bring a claim. And you have to act quickly. On the one hand, that's a problem. It probably does put people off, and particularly for something like pregnancy discrimination, the time limit's a real issue.
Yeah, that's another video, isn't it?
It is. But my point is that if someone wants to gratuitously lie for financial gain and say that her boss felt her up when he actually didn't, then she's going to bring that claim regardless. And we have to hope that most of those cases are seen right through. But when you have someone with a genuine complaint that's low level, the uncomfortable staring, or the guy that insists on rating every female graduate out of 10, those claims often don't get brought.
So Mr. Slightly Sleazy newspaper columnist is unlikely ever to be on the receiving end of an ET1.
Very unlikely, and probably quite right too, but the thought that he might just be enough to keep the worst of his excesses in check. And that's how we change the culture, at least in part.
I love your positivism.
As always.
I actually feel about employment law quite a lot. On a micro level, some of the claims are nonsense, let's be frank, and I sympathise with the employers who have to deal with them when they have a million better things to do. But actually on the macro level, most employees benefit from having those rights without ever needing to bring a claim. And the fact that some people bring a claim and they could do so if they needed to keeps the system honest. And if one of the achievements of Me Too is to make a few more women realise that the law is there and they can bring a claim if they need to, then that itself can be part of the culture change.
Quite, and there's so much more we could say. The war stories, the harassment cases, the most interesting I've dealt with. But I'm afraid we're going to have to wrap it up there.
Oh. Well, thank you for watching. If you've enjoyed this or any of our other videos, we'd love it if you could share or link to them.
Or even subscribe to our YouTube channel. Thanks very much.